Before we talk about what a garnishment is, let's talk about what a creditor and a debtor is. So a creditor is someone who is owed money. A debtor is someone who owes the money. And under Oklahoma law, a creditor gets to proceed against a debtor by following the money. The creditor is entitled to proceed against any person whom the creditor believes in good faith is in possession of some of the debtor's property. So when it comes to employers, that means that the employer, in providing paychecks, wages to the employee, would be in possession of some of the debtor's property. In a garnishment proceeding, the employer would be referred to as a garnishee. There are a number of different kinds of garnishments under Oklahoma law. Some of them relate to child support payments. Some of them are general garnishments. But for today's purposes, we're going to talk about continuing earnings garnishments. Those are the ones that employers tend to see the most often. And that's when a creditor files a garnishment against an employer in order to get at the debtor's employees' paychecks. When you receive garnishment paperwork in the mail, typically what you're going to see is what's called an affidavit, and then you'll also see a summons. Those documents will be labeled at the top. They'll have a case caption where you, as the employer, are listed as the garnishee. When you receive that paperwork, you need to carefully review it. The garnishment forms in Oklahoma are pretty good because they lay out all of the instructions that you need on how to file an answer to the garnishment.
Follow the instructions on the summons, which should include a copy of the answer form. You must file the answer with the court clerk within 7 days of the end of the present pay period or within 30 days of receiving service of the summons, whichever is earlier. As you will see on the answer, you must include information such as whether you employ the employee, whether you're indebted to the employee, or whether you are otherwise liable to the employee. When you file the answer with the court clerk, make sure you send a copy to the plaintiff's attorney or the plaintiff directly if they're not represented. You must also provide the defendant with a copy of the calculation sheet, notice of garnishment, application for exemptions, and an application for hearing. These forms should be included in the summons. You should deliver these forms to the defendant via hand delivery or to the last known physical address.
The most common missteps that I see clients make when attempting to respond to garnishments are 1, failure to file an answer at all, which is bad. Number 2, failing to file the answer on time. 3, failing to fully complete the answer form so that it's deficient. 4, when you have an employee who's no longer employed, and that's the subject of the garnishment, employers thinking, I don't have to file an answer. That's not actually the case. You do, and there's a spot on the answer form for you to indicate that that individual is no longer employed. And 5, the final misstep that I see the most often from employers is when there's already a garnishment for that individual employee in place. And so the employer thinks, I don't have to file an answer for this new garnishment. Again, that's not the case, and there's a spot on the answer form for you to indicate that there's a prior garnishment in place and provide some information.
Garnishee must file their answer within 7 days after the end of each pay period with the court clerk. This means that each pay period you must complete the answer and the attached calculation sheet. You should also mail a check to the plaintiff's attorney or the plaintiff directly if they're not represented by an attorney. The garnishment remains in effect until the judgment is paid, until the summons is dismissed, or for 180 days. This requires you as the garnishee to track how much has been paid to the plaintiff so you don't overpay the plaintiff and you know when your obligations end. Generally, the first person to file remains first in line over other potential plaintiffs. This remains true for a 180-day period, and so long as that first in line person files, they maintain priority over others.
It's so important to get garnishments right because as the employer, you could end up being liable for the underlying debt. So whatever your individual employee owes to a creditor, you could end up being on the hook for that. And that can be thousands of dollars. For example, I've had clients recently who failed to answer or failed to timely respond to court orders, and they faced potential judgment against them for $20,000 to $30,000. And this is such an easy thing to get right if you just look at all of the forms that you're receiving and follow those instructions. And if at any point you're confused about what your garnishment obligations are, pick up the phone and call an attorney. We look at these statutes all the time and we can help guide you through them.